Supreme Court has sided with the National Rifle Association in a case involving New York State.
Liberal Justice Sonia Sotomayor wrote the high court opinion. The case stems from a lawsuit against a New York official who urged banks and insurance companies to cut ties with the NRA, siding with the National Rifle Association. Government officials cannot attempt to coerce private parties in order to punish or suppress views that the government disfavors.
NRA's free speech rights were violated by Maria Vullo, a former state financial regulator. Vullo violated the First Amendment by coercing regulated entities to stop doing business with the NRA and punish the group.
Use third parties as intermediaries to censor speech. And that was a principle that came out much earlier in Bantam books in the 60s.
Former President Donald Trump is scheduled to speak to the group. That'll be on Saturday.
Free speech fight. In a decision that cautioned public officials against using their authority to censor speech they disagree with, the U.S. Supreme Court on Thursday reopened a case brought by the National Rifle Association, which accused a state official in New York of pressuring financial institutions to avoid doing business with the armed rights group. Judgment dismissing the NRA's 2018 lawsuit against Maria Vullo, a former superintendent of New York's Department of Financial Services, was overturned by the justices in a 9-0 decision written by liberal Justice Sonia Sotomayor. Issued here is whether, in exercising her regulatory authority, Vullo violated the First Amendment rights of New York financial institutions by pressuring them to sever ties with the National Rifle Association. The NRA claimed that Vullo was engaging in unlawful reprisal against it for its promotion of armed rights, which is protected by the Constitution, by imposing an implicit censorship regime on the organization in the aftermath of the Parkland, Florida high school massacre of 2018 that claimed the lives of 17 students and faculty members. Ultimately, the critical takeaway is that the First Amendment prohibits government officials from wielding their power selectively to punish or suppress speech, directly or, as alleged here, through private intermediaries, the judge said. A powerful Republican lobby group, the NRA has supported landmark cases that expanded arms rights in the U.S. and opposed arms control measures supported by many Democrats. The NRA claimed in its lawsuit that it was threatened with the loss of essential banking services and that its advocacy activities was jeopardized by New York's blacklisting effort. The amount of the damages requested was not revealed. Following the Supreme Court's decision, the case will go back to lower courts for additional review of the NRA claims in light of the criteria outlined in the decision.
This NRA convention is known as the largest gathering of Second Amendment supporters, with as many as 75,000 people.
Everybody, or the majority of people coming together, are all like-minded.
Large gathering, 70,000 people is an enormous turnout. So you can feel the energy building.
Former President Donald Trump being the keynote speaker, this event is certainly generating a lot of excitement as well as a lot of skepticism.
Advertising openly that children are welcome to come to this event when we know firearms are the leading cause of death for children and teens.
Disfavored political groups. A member of the ACLU's advocacy division who defended the NRA, David Cole, stated that the decision confirms that government officials have no business using their regulatory authority to blacklist disfavored political groups. After the Parkland massacres, Vullo, who was nominated to her position by a Democratic governor, asked financial institutions to weigh the reputational risks associated with working with groups advocating for the right to bear arms. After a former student with an AR-15 went on a rampage in Parkland, Florida at the age of 19, the NRA attacked those who wanted stricter arms control laws, claiming that Democratic elites were using the tragedy to further their agenda of arms control. Following an investigation by Vullo's office into the sale of the Carry Guard product, which was sponsored by the NRA, the insurance company Lloyd's of London and two others were fined over $13 million for violating New York insurance law. This program covered policyholders in the event that they were legally responsible for injuries caused by arm shot, regardless of whether the arm was used wrongfully. As a result of New York's legal stance, the insurers decided to discontinue providing NRA-endorsed products. While its primary location is in Virginia, the nonprofit organization's organizational documents are based in New York. The right to keep and bear weapons guaranteed by the Second Amendment was not at issue in this case. Arguments were presented to the Supreme Court in March. With the exception of 2 free speech counts, a federal judge in 2021 rejected the whole of the NRA's lawsuit against Vullo. In 2022, the Second U.S. Circuit Court of Appeals in Manhattan found that they should have been rejected as well, which led the NRA to appeal to the Supreme Court. Vullo faced lawsuits in her public and private roles. However, the Second Circuit determined that Vullo would be immune from civil litigation under the legal theory of qualified immunity, which protects officials from such cases in specific instances. In her decision, Sotomayor stated that the Second Circuit is free to revisit the qualified immunity question in light of this court's opinion. The court's judgment disappointed Vullo's lawyer Neil Katyal, but he stated, "We are confident Ms. Vullo's claim of qualified immunity will be reaffirmed." The NRA was surprised to find an ally in the Biden administration. In spite of Biden's claims that armed crime is a national disgrace, his administration pushed for the judges to grant the NRA permission to continue with its lawsuit. 2 cases involving the right to bear arms are anticipated to be decided by the Supreme Court within the month of June. A federal ban on bump stock devices, which allow semi-auto arms to fire rapidly like mash guns, is being challenged in one case. The other one challenges the constitutionality of a federal statute that criminalizes the possession of arms by those subject to restraining orders pertaining to domestic attack.
It will be probably the safest, most secure place you can find in town. Many preparations underway to make sure that it is a safe and fun experience for NRA members.
NRA filed for Chapter 11 bankruptcy on Friday with plans to regroup in Texas. This is a gun rights group, of course, very influential in Washington, especially in Republican administrations.
Decision on National Rifle Association. The unanimous decision of the U.S. Supreme Court in NRA versus Vullo raises 2 questions of First Amendment law that could use some clarification. At what point does state interference with private speech become censorship in violation of the Constitution? How may the words of public officials be used as evidence to determine whether or not an act was intended to be unconstitutional? The ruling raises more issues than it solves in the end. The NRA's lawsuit against Maria Vullo, the head of the New York State Department of Financial Services, has a legitimate First Amendment basis and can move on, according to Justice Sonia Sotomayor's judgment, which was joined by all 9 justices. It is very early in the litigation process, so it is unclear whether the NRA will win. The events that led up to the current disagreement began in 2017, when the DFS started looking into Carry Guard, an insurance program that was associated with the NRA. Carry Guard offered coverage for intentional criminal conduct, which is against the law in New York. Also seemingly breaking New York law, the NRA was pushing Carry Guard without an insurance producer license. Following the Parkland, Florida school slings and the launch of the probe, Vullo and others met with executives from insurance companies that did business with the NRA, such as Lloyd's of London. In order to pressure third-party corporations into ending their agreements with the NRA due to the NRA's constitutionally protected support for arm rights, the lawsuit claims that Vullo and then New York Governor Andrew Cuomo utilized the prospect of adverse regulatory proceedings. Despite the Supreme Court's decision to overturn the U.S. Court of Appeals for the Second Circuit, Sotomayor's judgment supports the lower court's approach for determining whether a government communication is unconstitutionally coercive. Important factors that the Second Circuit considered were 1. Word choice and tone, 2. The existence of regulatory authority, 3. Whether the speech was perceived as a threat, and perhaps most importantly, 4. Whether the speech refers to adverse consequences. As the case shows, Vullo had direct regulatory and enforcement authority over all insurance companies and financial service institutions doing business in New York. For instance, her messages gave the impression that Lloyd's might sidestep possible legal action by severing ties with pro-arm organizations. Lloyd responded to her messages in a way that suggested it recognized danger. In sum, Sotomayor concluded, when taken as a whole, the complaint credibly claims that Vullo threatened to use her authority against individuals who did not support her effort to penalize the NRA for its armed promotional activities.
NRA's free speech rights were violated by Maria Vullo, a former state financial regulator. Vullo violated the First Amendment by coercing regulated entities to stop doing business with the NRA and punish the group.
Use third parties as intermediaries to censor speech. And that was a principle that came out much earlier in Bantam books in the 60s.
Former President Donald Trump is scheduled to speak to the group. That'll be on Saturday.
Implications in Murphy versus Missouri. The NRA may have infringed on First Amendment rights, according to the Supreme Court's ambiguous Vullo versus Rhode Island majority decision. Case law from 1963's Bantam Books versus Sullivan, in which a Rhode Island commission sought to force intermediary book distributors to remove specific publications from circulation in violation of the publisher's First Amendment rights. Justice Ketanji Brown Jackson noted that this case is different. If a city's health agency is looking into minor infractions of its restaurant code, such as selling or donating food to student demonstrators on campus, the court's reasoning could be relevant. This makes one wonder whether the court's reasoning would be relevant in a situation where a city's health department expressed interest in looking into minor infractions of the restaurant code committed by establishments that provided food to student demonstrators on campus. The dissenting opinion that Sotomayor wrote 6 years ago in Trump versus Hawaii, in which she struck down a presidential order that barred citizens of 8 foreign countries from entering the country, 6 of which had Muslim majorities, resonates with her decision in Vullo. Chief Justice John Roberts wrote the judgment for the 5-justice majority, which found that the court had to take Trump's words into account while assessing a seemingly neutral presidential directive that dealt with an issue at the heart of executive authority. Murphy versus Missouri, Biden administration versus social media firms, potential unconstitutional pressure to remove or reduce COVID-19 misleading posts, is another case that will be fascinating to watch for the court's treatment of the question of coercion. 3 physicians, a news website, a healthcare activist, and 2 states had their First Amendment rights violated when the Fifth Circuit Court of Appeals for the U.S. determined that the White House and 4 other government agencies had essentially instituted a system of informal censorship of prominent social media platforms. That's all for this video, folks. See you next time.